So a big thank you to all the attendees who are here today. It's amazing to see so many of you have signed on to this. So hello everyone, thank you for joining us on a Saturday. The recording of this webinar will be posted on the Women's Place UK YouTube channel. If you've joined us on Zoom, the links to this channel will be provided in the chat room, and the panel's YouTube links are, sorry, the panelists' YouTube links are in the invitation email that was sent out to you. If you're watching the recording on YouTube, you can find the links in the description box below. If you need help with watching the webinar or are operating on Zoom, you can ask in the chat box, and someone from Women's Place UK should hopefully, fingers crossed, be able to assist you. And please remember, tweet throughout using the hashtag WPUK Equality Law with a capital E and a capital L. So hashtag WPUK Equality Law. So today, Women's Place UK are delighted to welcome our two panelists. We have Audrey Ludwig and Elizabeth Hungerford. Audrey is a discrimination solicitor who regularly puts her head above the parapet, tweeting openly as @Audrey Suffolk. I'm sure many of you, as I am, are following her. As part of Audrey's commitment to public legal education, she gives her general opinion where she thinks people have got rights under the equality law. More recently, she's done so with regards to the somewhat heated gender identity, trans rights versus women's rights conflict. We also have, joining us from across the pond, Elizabeth Hungerford, who is a licensed, though not currently practicing, attorney in the Commonwealth of Massachusetts. She identifies herself as a feminist, lives as a lesbian, is a long-time observer and sometimes commentator on matters of sex and gender in American law. Her opinions are solely her own. So let's jump straight in to the first question, which is, we know the debate around sex-based rights and trans rights has become very contentious, especially in recent years. How did both of you become involved in this arena? And I'll go to you first, Audrey.
Hello, and thank you very much for inviting me. I'm very much an accidental participant in this process. I'm a jobbing discrimination solicitor. I help clients from all of the 9 protected characteristics in my little part of England. And really wasn't engaged. I was very much a sort of feminist lightweight. As part of the work I do in schools, I stumbled across a document from an organisation called All Sorts, which set out, they claimed what were the legal rights of trans young people in schools. And I was very concerned that it looked at the equality law through a very narrow trans lens and ignored issues around indirect sex discrimination, the rights of young people of faith, etc. And it felt very unbalanced. And I mentioned it on Twitter and got complaints to my organisation. And rather than deterring me, it actually made me slightly intrigued, and I sort of fell down the Alice in Wonderland hole of this debate, and I've become more engaged with it, mostly because of my being an equality law nerd. I want the Equality Act to be properly interpreted, and I want discussions about proposed new laws to be carefully debated, analysed and reasoned upon, and that's really how I got started.
Oh, thank you for that, Audrey. If we jump over to Elizabeth, how did you first become involved?
Yes, well, first, thank you for having me. It's such an honor to be here from the United States to talk with Women's Place UK today. And I do want to emphasize that I am not a practicing attorney. I am just a commenter here. So while Audrey has some experience in litigation, I do not. So of course, my opinions are only my own. My involvement reaches back several years. And so almost 10 years, I would say, going back to the year 2011, I was a co-author of something that we affectionately refer to as the UN letter with Kathy Brennan. At the time, I was an anonymous feminist blogger, and Kathy Brennan reached out to me about this trend here in America at the state level regarding anti-discrimination statutes where gender identity was either being merged with sexual orientation or just simply being added along with sex and the other protected characteristics. And we had a number of concerns about how the definition of gender identity was both being constructed as a definition, and then also how it was being deployed in some cases as an actual override to sex in limited situations. And I'm gonna share my screen because I thought we might look at an example of one of those statutory provisions to get us started here today. Let's give me a moment. I'll share my screen.
Where it all goes wrong, Elizabeth.
Of course, right? Let me share my screen. Can you all see that?
We can, yeah.
I'm gonna put it into the full screen mode here. This is the legal definition of gender identity that we have here in the state of Massachusetts. And it's a little bit more complicated than some of the other statutes, but I think it makes a nice example. So one of our concerns back in 2011 was that gender identity is defined in a circular manner. So gender identity shall mean a person's gender-related identity, appearance, or behavior. And of course, if you don't know what gender means, then you would not know what a gender-related identity, appearance, or behavior means. So that was concerning. And then moving to the next clause here, you'll see that this language is traditionally associated, I don't know if you guys can see my mouse here, but the referent here is basically stereotypes. So traditionally associated with the person's physiology or assigned sex at birth. So we felt that this was a sort of enshrining stereotypes or someone's relationship with stereotypes into law. And then moving on, in Massachusetts, we do have a requirement to show some kind of evidence. And I think this is unusual here in the United States. Many of the statutes do not include this requirement for documentation, sincerity, or duration. And almost unique to Massachusetts, but there are a couple other states that have this. And this final clause here mentions improper purpose. And I'm sure that many of our attendees today will appreciate how important it is to have a clause in your law that protects against fraudulent uses or potentially fraudulent uses of gender identity. Because where gender identity is allowed to override sex, there's a conflict of interest. And now I'm showing a slide that includes language from the public accommodations section of Massachusetts law. And here in the text that I've highlighted in red, you'll see that where a place lawfully segregates or separates access to the place of public accommodation, so of course that's implying that there's a lawful reason or permissible reason to sex segregate on the basis of a person's sex, shall grant all persons admission consistent with gender identity. So that is the precise language where gender identity comes to override sex. And that is the core of the conflict of interest that we're still talking about and dealing with today. So I'm gonna stop sharing my screen and say that, to the extent that we're still talking about that, less has changed than I would have hoped in the past 9 years. and we'll talk about this a little more later, but the fact that you invited me here to talk today shows that at least some people are more interested in the problem than they were in 2011 when Kathy Brennan and I wrote that letter.
All right, thank you for that. So staying with you, Elizabeth, in the US, you've recently had the decision by the Supreme Court in the important case that goes by the name of Bostock. Mm-hmm. Can you explain a little bit about what that case was about and the significance of that case in the current debates regarding sex-based rights?
Yes. So the Bostock case is a historic decision with national impact, and the protection that it provides is for transgender and homosexual people. So gays, lesbians, and transgender people are now protected from irrational employment-based discrimination in the United States. And the Civil Rights Act of 1964 had not previously been interpreted to protect gay and transgender people in America. So while, you know, I live in the state of Massachusetts and we have, we're a very liberal state, we have anti-discrimination protection for both gay and people claiming gender identity. We just talked about that state statute. People in other states had no protection whatsoever. So over the past more than 50 years, an untold number of people may have been fired or refused to be hired because of their homosexual or transgender or perceived status. So that's sort of the core of the Bostock decision. It's really, really important. There's been a lot of talk about what transgender status means in the context of that case. And the Supreme Court did not actually define transgender status. They were even sort of hard pressed to define sex, even though that was the entire basis of the case and the ruling itself. But one of the most important parts of the decision, in my opinion, is that the court did firmly root their decision in biological distinctions between male and female. So they really required us to know what someone's physical sex is in order to determine whether they might be homosexual or transgender for the purpose of the law. And so I think that reference to sex as biological is extremely promising to future cases that might be brought under Title VII going forward.
Wow, thank you for that. So Audrey, regarding the GRA in the UK, we've had some significant cases going on at the moment, going through the Employment Tribunal and appeal. For example, the Maya Forstater case, which many of us have heard about and were following as it went through. But for those of us who are less legally versed in that case, could you tell us what the case was about? Why did Maya lose, and what are her grounds for appeal?
Right. It's quite unusual to be talking about a first instance employment tribunal claim, because normally you talk about cases that are from the Supreme Court or the Court of Appeal rather than something which is not a precedent case as such. But it was very obvious to everybody that the case was of great significance because it was essentially the first of its kind and is likely to go to through the appeal courts. I think that's the general view on it. Basically, Maya Forstater worked on some kind of contract for an NGO and had expressed some comments on social media about her belief in gender critical feminism and her concerns about proposed changes to the Gender Recognition Act. there's quite a lot of mythology which goes on about what she's supposed to have done to supposed colleagues, but there's no evidence that she did harass any colleagues or anything like that. It was simply that she'd expressed views which were largely political about her concerns and about her own belief in gender critical feminism. For that, she essentially had her a contract which she had understood that she was going to have renewed, terminated or not renewed, and this was the basis of the claim in discrimination law under the Equality Act to the Employment Tribunal. The claim was founded in sex discrimination, but for the purpose of the hearing that happened, it is also founded in the protected class of religion and belief, because religion and belief incorporates philosophical beliefs. And I'm going to share my screen. I'm going to try and share my screen and see if I'm technologically incompetent, so you'll have to bear with me.
Audrey, aren't we all?
Yeah, so let's just see if I can do it. Right, let's see if I can get it to...
There you go. While you're doing that, Audrey, I just point out that Maya is actually has joined us today. So, hello, Maya.
Hello, indeed. Yes, I can't work out how to do large screen, so I'm just going to have to leave it there, I'm afraid. But basically, the preliminary hearing was about whether Maya Forstatter's belief or lack of belief in gender identity theory was protected under Section 10 of the Equality Act. And I've got a typo there, but anyway, as with all belief cases, it has to apply the principles that are set out in an earlier case called Granger and Nicholson. So they had to decide whether the belief was genuinely held. It was a belief and not an opinion or a viewpoint. It was a belief as to a weighty and substantial aspect of human life and behaviour. It attained a certain level of cogency, seriousness, cohesion and importance, and it was worthy of respect in a democratic society, was not incompatible with human dignity, and didn't conflict with the fundamental rights of others. And as I understand it, the judge came to the conclusion that it failed on the final point, and he referred to the absolute nature of Maya's belief, or his perception that her belief was absolute. And also there was some conflation of a concern that she would misgender people, though there was no evidence that she had misgendered people at her workplace, or there was anybody trans to misgender. But there seemed to be some conflation between belief and the application of belief. It's obviously a very controversial decision, and there's actually, unusually for a first case, there's been a number of academic law and practicing lawyers writing articles about it. Most notably, people might look at Karen Moynihan's QC's article, which, as she is one of the leading equality law QCs, and she's very much of the view that it's likely that the Forstatter decision will be overturned on appeal. The reason for that is that you shouldn't really conflate the belief with the second element of looking at it, which is about the manifestation of that belief. So, for example, it would be okay to have religious beliefs, but to proselytize in the office with colleagues who don't want to be proselytized to might be regarded as being harassment. So you have to differentiate the belief from the practice once one is in the office. And so, but there's also a consideration of whether the judge got the Article 10 freedom of expression principles under the European Court of Human Rights, the European Convention of Human Rights, correct in this case. Just after this case, there was another case, albeit not an equality case, but there was a case in the High Court, a judicial review, which is a review of public law practice, called Miller and the College of Policing. If I've got time to mention it briefly, basically Miller was about discussion on social media about the conflict between trans rights and women's rights. It was probably done in a sort of slightly robust way, and a member of the constabulary in Humberside decided to turn up at Mr. Miller's workplace and through a series of conversations seemingly warn Mr. Miller about his behaviour, albeit that it wasn't criminal behaviour. And
is this the Fair Cop case?
This is the Fair Cop case, yes, indeed. And some of the conduct of the police and also the policy of which the police forces operate under was held to basically breach Article 10 of the European Convention, in that such speech, even if it's expressed in quite a robust way, maybe even offensive, as long as it doesn't amount to hate crime, is not unlawful. And that decision in the High Court will probably be a factor in any appeal when it happens of the Forstater case.
Thank you for that. If I turn to Elizabeth now with the next question, which is going back to the Bostock case that you were referring to previously. Now, Wolf points out that transgender status is not defined, yet with this decision becomes a new protected class. On that point, we've got a question in basically saying that there are disagreements in the US between US feminists over the interpretation of Bostock. Some feminists are on completely different side of the argument from you and say it was a bad decision. So what do you say to that?
Well, of course, I think reasonable minds could always disagree. But my reading of the Bostock case is that it's very focused, and this is, it's very focused on individuals. And this seems to be part of a more modern philosophy around anti-discrimination law, and perhaps even specific to the Roberts Court, the Chief Justice Roberts, in that we have a very conservative leaning government right now, as I'm sure all of you know. And they are not sympathetic to a lot of class action lawsuits or claims that groups of people are aggrieved and deserve a remedy. And so when we say, oh, a new category of people has been created, I think it's more accurate to say that a protected characteristic, or a characteristic that is protected, is being transgender. I don't think it means that transgender people as a group have been defined, and the Bostock decision did not provide any definition for transgender people or individuals. It was very clear that the remedy is related to discrimination against an individual or one person at a time.
Got you. Okay. Back to Audrey. As a discrimination solicitor, you've had a career representing clients using the Equality Act. You've been intervening into the discussion about the relationship between the Gender Recognition Act and the Equality Act 2010, particularly answering questions and putting your views on Twitter, as well as in blogs and through events like this. So for the audience, can you outline what you feel the key issues are in the UK currently, and what prompted you to intervene and speak up in this very difficult field? You've partly answered the question previous, but what do you think the current issues are at the moment?
Right. Well, I've got a number of key concerns, some of which I've outlined in the couple of the blogs that I've written for Women's Place UK. particularly concerned about the proposed changes to the Gender Recognition Act, not particularly about the process of getting a gender recognition certificate, but rather understanding the consequences to the Equality Act of an unknown number of people seeking to do so. A lot of people don't understand the co-relationship between the Gender Recognition Act and the Equality Act. And so if I might just sort of try and explain it, I'll see if I can share my screen. I might have to whiz through and try and find, it might take me a moment, but basically the Gender Recognition Act, Section 9, sets out that, I can't do that, anyway, basically when you get a Gender Recognition Act, Section 9 applies, and it suggests, albeit I don't think this is very good wording, that for all purposes the acquired gender, the acquired gender is the male gender, the person's sex becomes that of a man, and if it's the female gender, the person's sex becomes that of a woman. So you can see that the Gender Recognition Act conflates sex and gender, but the meaning of it is that for all purposes, one's legal sex is changed. It does say for all purposes, it isn't for all purposes. It bizarrely, subsection 2 and 3 and other parts of the Gender Recognition Act and indeed the Equality Act set out circumstances in which it's not for all purposes, but in practice, for most purposes, one's legal sex is changed on acquiring a gender recognition certificate. The reason why it's so important is because a lot of rights for women are dependent on the definition of sex and the use of comparators within the Equality Act in the UK, both in England and Wales and in Scotland, we have the same Equality Act. So essentially, whilst the Equality Act interprets woman means a female of any age under section 212 of the Equality Act, actually implicitly it means woman means a female of any age plus somebody who's got a GRC taking their male gender to female sex, as it were. The reason why that's important is because of the issue of sex discrimination. If we're looking at direct, indirect sex discrimination, looking at issues like equal pay, we have to think about comparisons. And if you've taken somebody out of what I've described as boxes, taken somebody out of a woman's sex box into a man's sex box, or vice versa, for comparison purposes for something like direct discrimination or equal pay, somebody could have been a comparator, being paid more or treated better or whatever, suddenly stops being a comparator. Now, whilst that may not affect people in a lot of occasions, no one has done any research or analysis to assess whether there would be any effect either nationally or in individual workplaces where somebody might have a equal pay claim in respect of another person disappear effectively by their acquiring a gender recognition certificate, or similarly direct or indirect discrimination being affected similarly, because both rely on comparisons within the text of the sections within the Equality Act. And as I say, I don't know whether there will be a problem. I just look at a situation where at the moment we have just about 5,000 people with gender recognition certificates in this country, some of whom will have gone man to woman and some would have gone woman to man, but they haven't got a good idea. If we get up to 200 to 500,000 people, which is the Stonewall and the government estimate of people who are within the definition of transgender, if a significant number of those people decide to go for a self-ID gender recognition certificate, whether this will have any effect on women's sex-based rights. And as I say, I'm not a legal academic. I'm not a government analyst. What I'm seeing is the absence of the debate, the analysis, the research on these issues as a practicing discrimination lawyer, and that concerns me.
If I might just, going back to what you said, Audrey, about the language of the Gender Recognition Act actually confusing sex with gender.
Yeah.
I'll just add that we have that same situation in the United States. If you look at even some of the federal document identification change administrative regulations, that gender is used as a complete replacement for sex with no definition or explanation for why one type of thing can completely replace the other. It's really unprecedented in any other area of law. I've never seen it.
And I think the key difference with, say, UK legislation or, you know, England and Wales and Scottish legislation compared to the US federal legislation that I've seen is that we have, for more than 10 years, had a specific protection against unlawful discrimination for people who fall within what is now the protected class of gender reassignment, what is now Section 7. The definition is somebody has the protected characteristic of gender reassignment if the person is proposing to undergo, is undergoing, or has undergone a process or part of a process for the purpose of reassigning the person's sex by changing physiological or other attributes of sex. Now, the interesting thing about that is I've used that section to challenge unlawful discrimination. I know that unlawful discrimination happens against trans people, and I've used that section, and actually it incorporates practically all trans people under the sort of broader umbrella. I mean, you know, essentially a single doctor's appointment or a single act of wearing different clothing or using a different name or something would get one within that definition. So it's a very broad definition, and certainly in practice we do not see any issues whereby people do not have rights against unlawful discrimination or harassment in this country under gender reassignment definition. So when there is discussion on social media, etc., about trying to enforce rights with regard to unlawful discrimination, it's actually a bogus argument. What they're actually looking to do, and I'll go on to talking about this if you'll indulge me, is about the sex-based exceptions to the Equality Act, Lucy. And that's the next concern I've got, which is around the misrepresentation currently by a lot of organisations of the sex-based exceptions in the Equality Act, and the campaign that Stonewall and others were bidding to essentially remove the sex-based exceptions from the Equality Act. You know, I mean, there's a whole raft of exceptions with regard to services, premises, occupational requirements, political representation in parties, all of those sorts of things. And they all exist. They were legislated for in 2010. A lot of them actually came from the Sex Discrimination Act. They were legislated for in 2010 because Parliament saw that they were necessary to safeguard women's sex-based rights, primarily women. So, you know, and yet you're looking at the debate at the moment as if it's all about trans people's rights. And I don't have a problem with trans people campaigning to remove the sex-based exceptions, whether it's in sport, whatever. They have every right to campaign for it. But on the other hand, women have every right to campaign for the preservation and enforcement of those rights.
Absolutely. I mean, as you both pointed out, there does seem to be a complete, whether it's deliberate or not, we go on to my next question, a conflation of gender and sex. We're seeing it more and more now, where we are seeing what is your gender question rather than the what is your sex question. Do we think that's deliberate, or is that just ignorance? I recall recently filling out a form for the Crown Prosecution Service in order to prosecute for them. There was a ton of questions on the equality questionnaire. Not one question asked me what my sex was. So you could have a situation where the Crown Prosecution Service take on 20 new employees and none of them are biological women, but by their own standards it looks like they have a 50-50 ratio. So do we think this is deliberate, or is this just a complete ignorance of the law? I'll go to Audrey first, and then if you sum up that quickly, and we go to Elizabeth.
I think it's both, and I think that it's also a breach of what's known as the public sector equality duty. I wrote a blog for WPUK, this published last week actually, about how to make policies Equality Act compliant. If you're a public body like the CPS, under Section 149 of the Equality Act, you're supposed to, in the exercise of your functions, have due regard in your policies to the need to eliminate discrimination, advance equality of opportunity between persons who share a relevant protected characteristic and those who don't, but also foster good relations between persons who share a relevant protected characteristic and those who don't. And equality monitoring is an essential part of that compliance with the duty. The fact that they are including in such equality monitoring issues or categories which don't reflect the Equality Act protected classes means that they cannot comply, because they can't statistically analyse whether they've got an issue with recruitment of women, or they've got a problem with, ironically, they've got a problem with recruitment of trans people. If you don't differentiate between those who are of a particular sex or a gender, then actually it affects men, women, trans men, etc. It's not good practice. It's very poor practice. Part of our problem is that the only body that can directly enforce the public sector equality duty is the Equality and Human Rights Commission, and they're very weak in this country. They've really, they've seemingly not understood about the fact that you have to ensure good equality monitoring, good statistical analysis to ensure that we are making policies, whether it's about recruitment, retention, services, whatever, that demonstrate whether there is direct or indirect discrimination.
So I'll bring Elizabeth in on that point. Are you seeing the same thing in the US?
Oh, absolutely, absolutely. I think perhaps some Americans who are listening will know there's at least sort of a belief that historically gender was used in place of sex to be polite, because it was right. People think
Absolutely.
of the sex act as opposed to physical or reproductive sex, and so that was the start of using gender in place of sex. But at the time, perhaps some decades ago, everyone understood that gender was just a code word for sex. But nowadays, of course, it means sort of self-identified sex. And that's, of course, much more problematic. And then, of course, the trans rights activists are very powerful. They're, they're very loud and persistent in terms of getting sex changed to gender wherever they might like that to be. So there may be some ignorance, but I think in a lot of cases it's intentional. And I think Audrey has nicely summarized some of the problems with that in terms of record keeping.
Absolutely. And that takes me into my next question to you, Elizabeth. But before I do, just to remind everyone that Women's Place UK are live tweeting at the moment. So do follow us on Twitter and do tweet yourselves at hashtag WPUK Equality Law. That's a capital E and a capital L. So tweet, tweet, tweet. So yes, Elizabeth. Party politics play a major role in these issues. It was crucial in the United Kingdom that women who were lifelong supporters of the Labour Party demanded answers from the Labour Party, that they felt that they were being thrown under the bus, that their rights were being trodden on, and that, as we know, we were being threatened with expulsion from the party. Now, it seems the backlash from women within the Labour Party has kind of sent the Labour Party into a bit of a disarray, but it's also sent warning signs to the Conservative Party. And personally, I think it's scared them off. It's made them take a step back from the GRA reforms that they were quite happy to push through. But they've seen what's happened in the Labour Party. They've seen the Labour Party completely implode over this one topic, and they've kind of taken a step back and like, oh, nothing to do with us, Gov. So do you think this will happen in the US, or is the attachment to the party or brand of the Democratic Party so strong that women in the US feel that they are unable to confront the party even when women's rights are at stake?
Well, that's a big question. One of the the first differences is, of course, we don't have a Labor Party in America. We have the Democrats and the Republicans, and the only other party that I think would make any mention is the Green Party. It's very small. And they sometimes run a third-party candidate on some tickets. And there has been, I understand, some controversy or debate within the Green Party about gender-critical views. But I think part of what's happening in the United States is that there just aren't enough, we don't have the numbers yet, or the mass that would be needed to come to something so large as the Democratic Party and say, hey, there's real dissent happening here. But I do encourage people to contact their local representatives, particularly the Democratic representatives, and talk to them about this issue. It is their job to listen to their constituents. And I think that really is the only way to start making change, is to bring these forward. And I know Women's Place UK does a lot of work in helping people craft messages for their MPs, and that's the kind of work that we need to do in the United States.
I think we're seeing in this country, and I've said this before, we seem to have managed to grab the issue by the scruff of the neck, but we've done it from the left. Like feminists have come forward, organisations like Women's Place, LGB Alliance, people like Julie Bindel, people who've been around forever, but real left-wing people have come through. Yeah. And when you talk about the gender-critical opposition to the GRA, in this country, you associate it with feminists and left-wing feminists. It doesn't seem like that's the case in the US. I'm not saying that's not what's happening, but it almost seems that your opposition is coming from a different place, from the Christian right or from the right wing. Does it make it harder for feminists in the US to therefore come out and be openly gender critical without being accused of being in the pocket of the lunatic right?
That's an interesting question. I mean, even back in 2011, with the UN letter, we were accused of being in cooperation with the religious right. And of course, that was not true. But we do see conservative religious right organizations getting involved in the law around sex and gender. For example, Alliance Defending Freedom, which is a huge nonprofit organization in the United States that does a lot of impact litigation. They represented Harris Funeral Homes in the Harris Funeral Homes versus Amy Stevens case, which was rolled up into the Bostock decision just last month. So we do see them getting involved, and it's been interesting. We actually do have some feminists who are working with them in the United States, and they have taken on some of the language that was previously used by feminists. For example, sex not gender. I actually own the sexnotgender.com website, but this past fall, there was a rally on the steps of the Supreme Court with Concerned Women for America, who are a conservative organization, and they had big signs in like cotton candy pink that were saying sex not gender. So they've really, the conservatives have really captured some of our language and hashtags or whatever to promote their own version of sex not gender. And of course, they are not gender critical in the sense that they want to abolish gender, but they think that sex-based social roles are natural and should be reinforced, and that people should not believe that they can change sex or change their gender. They should, get in line with those stereotypical boxes around how men and women should act. So it's very complicated, and it is, currently developing. So I know a lot of people are interested in talking about that, and it's very interesting.
Thank you. Audrey, we've just got a question in, just asking for a bit of clarification. Given the broad ambit of Section 7 of the Equality Act, is it the case that if a man was to use female pronouns, that he would come under the protection of Section 7?
It hasn't, to my knowledge, been tested in the sense that in practice, it is possible that a respondent might challenge whether they come within Section 7, but to my knowledge, essentially, when the claimant goes to the employment tribunal or the county court and claims to fall within Section 7, the gender reassignment protected class, essentially they just lay out their history, and it may be that they've just changed their pronouns or whatever, and then it would be for the court to decide whether they come within Section 7. But in the absence of that issue being having already been litigated, it's difficult to predict it. But my sense is that the courts are going to be very open to a very broad interpretation of what amounts to coming in within Section 7. So if I was a gambling person, which I'm not, if somebody was to have just changed their pronouns, I think that would probably be sufficient.
Right. So in that case, how can we on one hand defend the rights of trans people, but at the same time defend the rights to have the single sex exemption, if that is the case?
Okay. In practice, I think that there's a lot of myth-making and around the sex-based exemptions and how they apply. Mostly, the myth-making is that the 2010 Equality Act gives everybody who falls within Section 7 the right to use all women's single-sex services, etc., and that's not necessarily the case. What you have to look at in the use of the exemptions is the context of each policy or each service or each sport or whatever, and see whether the provider can lawfully come within those exceptions. By reference to whether it's a proportionate means to achieve a legitimate aim. It is perfectly possible to, with the right evidence, to exclude those who are biologically and legally, biologically male, and those who are biologically male but legally female, using a combination of, say, Schedule 3, sections 26, 27, 28. There is an assortment of exceptions with regard to separate sex services, single sex services, and exclusion on the grounds of gender reassignment. There's various exceptions that you can apply, and a service provider can choose to use them. Now, at the moment, because Stonewall have managed to institutionally capture a lot of public bodies, a lot of private organisations, and basically essentially say a combination of either you're getting the law wrong, service provider, and you have to include trans people, or alternatively they're saying you know, in order to be inclusive, you shouldn't use the exceptions, you should be nice to people. A lot of organisations are thinking that they are required to either not use the exceptions or remove those exceptions being applied. What they haven't thought about, and nobody has litigated yet, is whether a removal of or a failure to use a sex-based exemption is in itself indirect sex discrimination if the evidence shows that it has a significant adverse effect on women by not using it. So if I could take an example of sport, Section 198 of the Equality Act allows for essentially a single-sex exemption for what are known as gender-affected sports, where issues like safety and fair competition are affected. At the moment, a lot of these sports providers are making them inclusive because they are consulting with trans organisations and seeing the issue as trans-based discrimination. But what I'm not seeing in a lot of the discussions is any analysis, research, consultation about the effect on women's based rights, or indeed women of colours based rights, women of faith based rights, disabled women's rights, other factors. Should the exemption in Section 198 not be used? And I think one of the areas that people should be thinking about is whether we can use indirect sex discrimination or indirect discrimination on the basis of one of the other protected classes, if the evidence supports that, to challenge the removal of or the failure to use the exceptions. So that's a very convoluted argument, explanation. Does that help you, Lucy, or do you need a...
No, that does. Thank you for that. Next question to Elizabeth. Again, this is coming from our live chat as the questions come in. Elizabeth, would you say that the ratification of the ERA in the US is still very much a live issue?
To my knowledge, it is. It's a very short and simple, and I know there's been some discussion or question about how gender might intersect with the ERA. I don't have any reason to think that there would be any addition or particular interpretation of that in the absence of, judicial opinion or some kind of litigation around it, because it is a constitutional amendment. So it had to be challenged for interpretations to come through. And I believe there is a lawsuit pending now about the deadline related to ratification of the ERA. But if I might, I just wanted to go back to something that Audrey mentioned about sex-based exceptions and their sort of permissive nature. Audrey used sex-segregated sports or gender-impacted sports as perhaps the British term is. We have a case in the United States that's currently pending in Connecticut. There are a few high school females who were displaced in their track and field events by biological males competing on the female team. And to my knowledge, all of the sex or legally permissible sex segregated contexts and spaces are permissive, which means that the state of Connecticut has created a policy that allows transgender people or students to compete on the team of their choice. And while they might not run afoul of the law by enforcing sex segregation, the law doesn't necessarily require them to enforce that sex segregation. So it's a really interesting question, I think, in both of our countries about whether sex-based exceptions or exemptions can be enforced against anyone, or if it's merely the preference or right of a particular organization or institution to use them if they want to. Sure. And in fact, I think Judith Green gave a talk at some point for Women's Place UK where she gets into that in some detail. It's very interesting to listen to.
Thank you. I mean, a follow-up question to that really is, you've already talked about it already, the sex-based exemptions in the US, but does that only apply to education?
No, in a sort of classic American way, we have a whole bunch of different statutes, some at the federal level. The case in Connecticut with the track and field female students being displaced, that is a federal Title IX case. There are exceptions under Title VII potentially for BFOQs, which is fun to say. That stands for bona fide occupational qualification. And I believe there's a mirror provision in the Equality Act in the UK. Yeah. And then at the state level, there might also be legally permissible sex segregation in particular places like restrooms or bathrooms. And earlier I showed my slide in Massachusetts public accommodations where otherwise permissible sex segregation, the owner must allow people according to their gender identity. So it's kind of a hodgepodge or like a crazy quilt kind of thing. In the United States, we don't have that nice centralized Equality Act that lays things out more clearly, at least. I don't want to say perfectly clearly, but at least more clearly than what we have in the United States.
Sure.
I think one thing that's notable is that we actually have very little litigation on the, or rather litigation that's actually come to fruition on the sex-based exceptions in the Equality Act. I know that the Labour Party are being challenged at the moment with regard to the Part 7 104 women-only shortlists, but that seems to be meandering its way through the court at the moment, and I haven't seen any idea of when it's actually going to be decided upon. So, in practice, it's interesting because one of the things you really notice is a lot of the litigation that's gone on over the last few years, until really the Maya Forstater case and some of the litigation brought by Safe Schools Alliance, is actually most of the litigation has come from trans groups or trans individuals. And I think that we're seeing a change where it's going to start being sex-based rights that are going to be litigated on, and the focus is going to change, and I think that will be quite interesting as we go forward.
Coming back to you, Audrey, please, can you discuss the prospect of banning LGBT conversion therapy? I'm sure you'll agree that, you know, we're all in favour of banning the LGB conversion therapy, but many of us have concerns that adding the T will stop trans identifying children from accessing counselling that might help them find routes of well-being that don't involve medical transition and mutilation.
Yeah.
So for people who do want to address that and do want to put pressure on their MPs and want to reach out to their MPs and write to them, how would you suggest they best tackle it?
Oh, that's quite a tricky question. It's probably more of a political question than a legal question, because essentially the proposals are going to be within the legislation that may come out of the review that Liz Truss's department is doing at the moment. And so in practice, I would say lobby your MP, educate them on what the difference between converting people on the grounds of being lesbian, gay or bisexual means, as opposed to the sort of necessary work that needs to be done to help a young person through the whole issue of gender dysphoria. I mean, I think it's really interesting because I'm not an expert on this subject, but I mean, it's quite obvious that with regard to LGBT people, their sexual identity affects themselves and it doesn't really affect anybody else. It doesn't mean that they have to have surgery. It doesn't mean they have to have medical interventions. It's a social status, it's a legal status in the sense they've got protection under the Equality Act against discrimination on the grounds of sexual orientation, but it's not something which ends up being a medical issue, and I think that that's the big difference. You know, in practice, I haven't taken a very strong view particularly around it, but it, you know, obviously anybody who's a member of society is going to be concerned about very young people, some of whom may not even have acquired even, you know, sufficient understanding to acquire, you know, sort of Gillick type consent, competency, having fairly major medical procedures happening. Now, as I say, it's not something that I know enough about to comment on particularly, other than obviously it's a concerning area, and I think that some of the papers that are now coming out from some of the concerned psychologists and psychiatrists should be provided to the MPs, and just concerned that new medical treatments, untested medical treatments, have historically led to serious medical negligence issues. I mean, obviously, you know, things like, I can't talk about parallels because I don't know whether they are parallels, but historically, whether you're talking about thalidomide or whether you're talking about other medical treatments, there have been in the past situations where doctors, even doctors of goodwill and for the best intentions, have ended up giving treatments which have been that actually harmed people as opposed to help them. So I think, you know, real concern should be expressed in that area.
I mean, it's a real can of worms. It seems the wheels are coming off the cart, so to speak, on that debate.
Yeah, I mean, somebody like one of the barristers, like Sarah Phillimore, who's a child safeguarding specialist, she's a family lawyer, has spoken a lot about her concerns around a failure to consider both safeguarding issues with a lot of around a lot of the sort of gender literature, but also around literally the competency of children, legal competency of children to make such difficult decisions.
Yeah, absolutely. Elizabeth, I'll come to you next. So what do you think of the proposed Equality Act, which Joe Biden says he will be the very first thing that he will enact if elected? As you probably know, throughout the proposed bill, there is a total conflation of gender identity with sex and sexual orientation. There's a section in the bill on definitions where sex is defined as A, a sex stereotype, B, pregnancy, childbirth, or a related medical condition, C, sexual orientation or gender identity, and D, sex characteristics, including intersex traits. The bill specifically refers to public facilities, public education, shelters, federal funding, and conversion therapy. So, A, what's your thoughts on the Equality Act, and what are your thoughts on Joe Biden wanting to bring it into law as his very first act? Because obviously that's the most important thing that needs to be enacted in the US if he's elected.
Yeah, I don't think it is. I'm not sure when he said that, but I think in most people's minds, the Bostock decision really changed the landscape for the Equality Act. The Equality Act was designed to fill some of the gaps that have existed for a very long time in federal law here in the United States. And again, I think Bostock changes the landscape considerably. I would expect some revised or updated version of the act, the Equality Act, to come down at some point. And I'll be very interested to see it when it does, because the necessity for including, sexual orientation and gender identity, as a matter of principle, yes, but it's just not quite as urgent or necessary now that the Supreme Court has clearly stated that gay and transgender people are protected from certain firings, hirings, or other injurious discrimination on the terms of their employment. One of the things that I think is so interesting in the Equality Act, and this is going back to the religious right and the exemptions that they have put into law so that they might be, or people might claim exception from compliance with anti-discrimination laws on the basis of their religious beliefs. There's a particular statute called the Religious Freedom Restoration Act of 1993. So it's been around for a while. I think I was in high school when that passed. And it was described in the Bostock decision, excuse me, as a super statute. So it applies to many or most other pre-existing statutes or future statutes. And the Equality Act specifically says that the Religious Freedom Restoration Act should not provide a defense to any claim of discrimination under the Equality Act. And that's part of the reason why it couldn't pass in our current Congress, because it is so heavily weighted towards Republicans or people who, that's sort of a deal breaker in the Equality Act. I hope that any future version will continue to include that, because we do see the religious right, their organizations working very hard to not only create, because they have created, but to expand those little areas where people's religious beliefs can excuse them from providing protection or services to people that they object to for whatever reason, often women's reproductive rights, gay people, and of course transgender people as well.
So a quick follow-up question to that, just in regards to the details of what could be in the Equalities Act, but also the current details of the law as it stands. So does the process of legal gender recognition vary across the different states in the US? So for instance, could it be possible for someone to be legally male in one state and legally female in another state?
It is unlikely that that scenario would happen. But birth certificates, which are sort of the core of one's governmental identity here in the United States, they are issued by the states, and in a couple of circumstances by a city, like the New York City issues their own birth certificates. And so someone in, say, Massachusetts might be able to easily change their birth certificate to show themselves as their preferred sex rather than their physical sex, without doing much besides, say, providing an attestation, right? I self-identify, change my birth certificate. There are some states that require surgery, a doctor's note, and there are still, I think, a couple of states that will refuse to change birth certificates at all. They consider it a historical record and they just absolutely won't change them. So you have very different, depending on where you're born in the United States, you're bound by the laws in the jurisdiction that you're born in terms of your birth certificate and whether you can change it or not. So in some respects, it's sort of unfair because some people are able to easily change their documentation and other people who just happen to be born in one of the states where you can't change are not able to. And then, of course, there's also federal documentation, passports, social security cards, and those are also, there's, I think some medical evidence is required, but surgery is absolutely not required. So again, your birth certificate in your state might say that you're still your birth sex, but you're able to change your passport or your social security identification to say otherwise. So you can have, I guess in that respect, you could have conflicting identifications. There's just no centralized process.
Right, sounds a mess.
Well, yeah, I mean, we've got this odd position in the Gender Recognition Act where, because there are some exceptions to the Gender Recognition Act, one of them notably is primogeniture, whether somebody acquires a title in the aristocracy, that you can be legally male and female for different purposes on exactly the same day, which is it's a weird scenario. It's also about inheritance as well. It's very noticeable that organisations like Stonewall haven't really campaigned for changing the law on primogeniture or inheritance, but they have focused on women's sex-based rights instead, which is, I think that tells you that we've got a House of Lords as part of our parliament, I think, because they'd probably never get that through the House of Lords.
I'll come back to you, Audrey, actually. I'm a bit conscious of time, so minimal our answers. So as we've seen in some quite high-profile cases, Girl Guiding and the Women's Institute now admits trans girls and trans women who self-declare, but they don't admit other males. So can you confirm that in each case, is this sex discrimination against men?
The answer to that is I would have to give a different answer for Girl Guides than I would for the Women's Institute, and I'll explain why in a minute. The Girl Guides, I'm fairly confident that they are going to, my consideration is that they're going to lose the litigation that's going to happen, that is happening at the moment. There is a challenge by a guider to being expelled, and also her daughter, I believe, again, based on the policy. Now, I don't know the details of the policy, but certainly I'm concerned that the Girl Guide policy doesn't comply with the Equality Act. One of the notable things is that in the UK, you can't change legally your sex under the Gender Recognition Act and under the age of 18. So in practice, anybody under the age of 18 retains their birth sex. And a policy which seeks to exclude some legal males, even those who are identifying as girls, but doesn't exclude other legal males, is, in my view, sex discrimination against those boys who are not allowed to join, because they're not using the sex-based exemptions correctly, and therefore they can't rely on them as a defence to a sex discrimination claim by a boy. So I think that a claim by a boy to join the Girl Guides would be successful. A claim against the Women's Institute by a man will very much depend on their policy, and I don't know whether their policy allows for those who have a gender recognition certificate only, or all those who self-ID as women. If the former, then they probably can exclude those whose legal sex is male. But if they seek to include people who are self-IDing their gender as female, then again, I don't think they're using the exceptions correctly. And again, a claim by a man would be successful. Obviously, the claim in the Girl Guides case by the guider and her daughter are not by men, they're by women, and therefore the arguments are very different. But having looked at some of the paperwork, it looks quite a strong claim, though obviously I'm not part of that litigation.
Got you. All right, thanks for that. Explains it a bit. So I'll come back to you, Elizabeth, if I may.
Okay.
There you go. Some people have said that because female rights are under attack like never before, we should work with anyone, even the Christian right, and in some cases the far right, to work together to achieve our aims. What do you think about that position?
I'm strongly opposed to that position. I appreciate that a lot of people feel very strongly about it, but the religious right, they may agree with us on this one issue, but there's a lot more. I should say first, they agree with us for different reasons, right? We don't have the same reasoning for coming to sort of this particular conclusion about how public policy should be constructed. But their reasoning, sort of their reasoning is completely contrary to feminism, and I think to women's liberation generally. I mentioned earlier that, you know, a lot of conservative or religious people believe that we should all, you know, that sex and gender should not be confused because men and women each have their own rightful sort of place in society, and that we each need to comply with that. And so, you know, and of course the religious right also doesn't believe that women should have reproductive rights in relation to abortion. Some of the exceptions, many of the exceptions here in the United States, you know, that give women challenges or barriers to accessing birth control, you know, for gay and lesbians to adopt or to be foster parents. These are all issues where the religious right is completely against us, or you know, opposed to a feminist interpretation. And so I don't think that anything is gained by working with people on a single issue, when in fact their entire sort of social philosophy is about, depends on a conservative view of women's role in society. So I think it's unfortunate that some people do see this as just a single issue. I think it's a much I think part of feminism is having a holistic view of politics and not just this one issue.
Oh yeah, okay. Of course, we are all aware of the current debacle that's currently taking place over the very well written, eloquent letter that J.K. Rowling recently wrote. Of course, there's accusations against her, name calling, they're trying to burn her at the stake. Boko Haram have got their pitchforks out against her. So we're seeing this cancel culture that has been kind of rumbling along for quite a few years. Some people have been victims of it years ago. Many people like myself who are kind of very new to the debate are starting to see it firsthand as well. So we are seeing these vicious attempts by some to try and silence feminists, shutting us down, accusing us of being bigots, trying to get us cancelled. Like I said, I'm sure it's the same in the US as it is here. But amongst that, what we've also seen has been a mass movement of feminists who are starting to stand up. I mean, of course, we know that people have been standing up for decades now on this particular issue, but we're seeing more people than ever really sticking their head above the parapet, standing up, demanding to be heard and refusing to accept the mantra that trans women are women, refusing to accept that without question and demanding a debate. And we have seen the support for J.K. Rowling. We've seen that in the last month or so. That's come out. We've seen her book sales increase in the last few weeks, which has been a real sort of two fingers to her opponents. And of course, we also saw Alison Bailey when she set up her crowdfunder. Despite them, trying to rip it down every 2 minutes and sabotage it, I believe she raised something like £60,000 in the space of 24 hours. It's absolutely amazing. So we're seeing, actually, we may be a bit quiet, but feminists are coming out. We're really digging our heels in. We're not going to go away. The tide is definitely turning in our favour. We've seen that with what I think is going to be the rollback of the GRA. But what should women do in order, or how can women use the law in order to advance their rights? And what should we be focusing now on?
Who do you want to answer it?
I'll go to Audrey first. We
Right.
don't have much time left, so
okay, brief.
And then
well, I think use your talents. Certainly, I've started blogging more. People will have noticed something called Legal Feminist, which a group of women lawyers, practicing lawyers, have set up to blog on legal issues that affect feminists. And I think it's really good to check it out. Some really excellent blogs on that. I think that we should be thinking about a centralised fund for strategic litigation. I think that might be an area that people should start talking about. But I think it's also in their workplaces, in their hospitals, in their sports clubs, etc., challenging policies, challenging, polite challenge is the way to go. Some of them might result in cases. Some people won't be in a position to challenge because they're worried about their jobs and things, and I understand that completely. But actually, I've been complained about 3 or 4 times, and after a while, it starts to be water off a duck's back. You get hardened to it, and the point about it is that actually you just keep going. I've had the religious right allegations against me, which is absolute nonsensical. All of those sorts of things. Ultimately, those who are probably of an age that I am, who feel like they're probably not so job insecure as others, just go for it. Complain about the equality monitoring forms and the policies and the lack of single sex spaces and the harassment that they're getting, all of those sorts of things. I think it's just basically, emulate the suffragettes. I'm not saying that lightly. I know that's really hard for a lot of people, but in practice, we are not going to win on Twitter. We're going to win in our own spaces, you know, in our workspaces and in our public spaces, and we're going to win by writing to politicians. That's the reality of it. And
I mean, you say that we're not going to win on Twitter, but I think, and second, Elizabeth, I think the positive of the debate on Twitter is we're really seeing the difference in the tone of the debate.
Yeah.
You're getting very well thought out arguments, really well put together arguments coming from our side, and a complete shower of shite coming from the other side, just abuse and threats. And if you haven't been blocked by Owen Jones, you're going wrong in life. You know, I'm sure probably most people on this attending have been blocked by him and the Fox killer barrister. So same question to Elizabeth. What are your thoughts on it?
Well, I should say I agree with Audrey. I think we have to keep talking. And to your point, Lucy, about Twitter and the number of women who are speaking up on Twitter is just remarkable. You know, it's sort of grown exponentially. I don't think that litigation around cancel culture will be really effective. I mean, I personally, I've been libeled, I've been name called, it's been years. Yeah. And I think that bringing litigation makes it about you rather than about the, you know, women's rights as a class, as a group, and that our litigation, you know, should be focused on those cases for rights that affect women generally, and not about particular, you know, libel or slander against an individual who was canceled. But I think our voices have, as I say, exponentially grown, and the tide is hopefully turning. It's a long game. It's a very long game. It's very frustrating. But we have to keep speaking.
Absolutely. I think one of the things I'm really heartened by is the growth of the women's organisations in the UK. I mean, you know, WPUK, Fair Play for Women, you know, Safe Schools Alliance, they're awesome organisations. And it's been, you know, the people who've done the hard yards for years in, years out. And we've, you know, people like me are standing on, you know, the shoulders of goddesses like Julie Bindel. You know, these are amazing people, and, you know, we all owe them a lot of credit.
I think so, and I think the eyes of the world are actually watching the UK, because I think we're one of the few countries that have actually stopped this juggernaut in its tracks and have kind of sent the train back the other way. And I think there's a lot of positivity coming out of this country. And again, I really do think it's because feminists have grabbed this argument by the scruff of the neck, and they're leading the agenda on this argument. We're not being co-opted by right-wing organisations or religious groups. We're really leading it from a left-wing perspective. So it makes it difficult for people to attack us. I mean, they will call us bigots. I mean, I've been called racist and I've been called homophobic because they can't see my face on Twitter, so they assume I'm white and homophobic. But we know it has no ground, and most people know it has no ground. And I think that's why we are winning this debate in this country, and we are making some massive inroads. So on that, I would like to say thank you so much to both of you for joining. I thank you so much as well for everyone who's attended on us today.
Thank you.
I hope we answered as many questions as we could in the time we had. Keep tweeting, please retweet, tell us what you thought. Not too much if it's abusive, but yeah, please go on Twitter. Don't forget the hashtag WPUK Equality Law. And thank you so much again for everyone for joining, and we look forward to the next Women's Place UK events. Thank you so much.
Thank you.
Thank you.
Thanks, Lucy.
Cheers.